Judith Cochrane.
Thank you, Mr Speaker, and I welcome the opportunity to speak on this group of amendments to the bill today. Special advisers are important appointments and are also sensitive appointments, and as such, while we respect the considerable discretion given to ministers regarding appointments, there are nevertheless aspects that are matters of public interest. And there is a clear lack of public confidence in the current system and a perception that special advisers are exempt from controls and accountability. And for that reason, there is merit in improving the appointment protocols. As I had suggested at previous stages of this bill, this probably could have been achieved by placing the Code of Practice on appointment of SPADs on a statutory basis, which would have ensured a vetting procedure in line with the procedure applied for other civil service appointments. And indeed, the appeal mechanism that is now included in the bill does bring the procedures more in line with the DFP protocol. I therefore have no objection to Mr Allister's proposed amendments in relation to referring the appointments to DFP for a panel to consider. Moving on to the amendments proposed by Mr Bradley and Mr McGuinness, these amendments would appear to remove the major vulnerabilities of the bill, that is, the areas open to legal challenge. And of course, what we don't want to do is pass a bill that will inevitably end up being legally challenged and will in essence only provide income for lawyers. So whilst I take on board Mr Allister's comments in relation to the amendments 2, 5, 6, 7, 18 and 20, and that he says that this is a prospective bill, I do still have concerns about the retrospective implications of it and that it may fall foul of Article 7 of the European Convention on Human Rights. Retrospective laws have previously been accepted by the Court only when they have been in order to strengthen public safety. And there has been much discussion during the debate today around the Attorney-General's evidence at committee. And I have listened to the points made by Mr Allister and Mr Girvan, but I am still not sure whether the bill would merit the application of a retrospective approach. As for amendments 8, 9, 10 and 11, I'm content to accept amendments 10 and 11. And I could probably also accept Amendment 8, which uses language akin to that's in the vetting procedures for civil servants. It doesn't simply replace the word contrition with regret, but it goes on to say shows acknowledgement of and accepts the gravity and consequences of the events to which the serious criminal conviction relates. And again, there has been much debate on this today, and I think it's worth noting that any of this wording, be it regret, remorse or contrition, is quite difficult to prove, and it will therefore be up to the panel to have regard to this point, and therefore the onus will be on them to assess whether the definition of regret also goes further. Finally, in relation to Amendment 9, let me make it clear, Alliance are supporters of the Good Friday Agreement and accepted the logic in relation to the early release on licence of prisoners convicted of paramilitary offences before 1998. And not just the Good Friday Agreement, we also supported the St Andrews Agreement, which committed the two governments to working with businesses, trade unions and ex-prisoner groups to produce guidance for employers in order to reduce barriers to employment and enhance reintegration of former prisoners. This is a recognition of the much reduced risk of reoffending within a difficult political context. However, it does not mean that we would excuse what they had done, and therefore we cannot accept Amendment 9, which would remove the criterion expecting assistance in the investigation and prosecution of those connected with the offence. And this surely is the key point as to whether the individual has had real regret for what they have done. That's my comments for today. Thank you, Mr Speaker.
Peter Wee.